Oh, happy Thanksgiving. Sorry. Let me get this off. And yes, it's a pilgrim hat. A Galini tradition. My wife gets these, and we wear them every year. I've been wearing a turkey head all day. This is the turkey head. But we also have a pumpkin and a stalk of corn, and this is the pilgrim hat. So I wanted to do some of these questions in our festive Thanksgiving day, and, give thanks for all the wonderful things that we have in this country, which we do. And I am so grateful for this country. And even though sometimes I am critical of it, but that's because I don't like government. And because I don't like government, I'm going to be critical of government. Doesn't mean I don't love this country, and I don't absolutely love our Bill of Rights and our natural law and all of the freedoms and liberties that we should have. Okay, and that's what I fight for every day, is that we are secure in our liberty and our freedom. And special education and 504 is just a component of that. Okay, so in my festive gear, let me answer this question. And it says that your complaint is the district's lack of child find. And if it's child find, then that means that your child has not been found eligible for an IEP. Well, there's also a child find under 504, so it could be either one. And yes, in order for your child to be found eligible, depending on the nature of their disability, their qualifying disability, let's say your child has a severe ADHD or ADHD. Let's say your child has autism. And both of those things require, let's say a history of, you're going to have teacher rating scales for adaptive and behavioral rating scales that would be required to be filled out. But what's nice is to have anecdotal records and notes to support that your child has a history of issues, because, those rating scales are subjective and it's not an exact science. But yet I have so many kids that are not found eligible because of what I consider manipulations, whether they're intentional or not intentional, of the behavior and adaptive behavior rating scales conducted or filled out by staff. So you got some legitimate concerns there. Now, parent-teacher conference meeting notes, and I've never heard of a parent-teacher agreement, wouldn't necessarily be enforceable. But I guess one could exist in spirit. It's like spitting on your hand back in the day, and there you go. No court's going to uphold that. But I'm just saying, I'm not saying that they don't exist. I'm just telling you that there wouldn't be anything legally enforceable about them. Okay. So with that being said, if your child is referenced in those parent-teacher meetings, then it would be personally identifiable to your child, and therefore should be considered part of your child's education record. Now, a way to sort of sidestep their little excuses that they're giving you is that, on the outset of your meetings, you need to make it very clear in the meeting notes that you would like it considered an education record because it is personally identifiable to your child, and you would like that that record maintained in your child's folder. You can make that request. I can see where sometimes schools may say that there's a gray area there, or say that because it's not specifically dealing with your child's academics or other aspects of your child's, then it's not, they don't deem it an education record. I disagree with them. I believe it would be, as long as it's personally identifiable to your child. Now, with regards to Dojo, Isn't it amazing that you know, they have a tool like Class Dojo that will track class behaviors for all the students, and then have somebody misuse it, which everybody can. I mean, you know, hell, water can be misused, and that's, you know, we all need it to survive. But yet, you know, our own government's used it to waterboard people for torture. You know, you can drown in it. So, you know, it doesn't matter what it is. I mean, so Dojo could be created with the best intent, but, you know, it's amazing that people will find a loophole to use it for, you know, whatever, or as a way to skirt providing you with information about your child. But I can see where they'd sit there and say, well, you know, those were purged. They shouldn't have been. And I can tell you, my familiarity with Dojo is that every parent has access or a login, or you should, to be able to monitor Class Dojo and what the teacher is writing in there about your child. And if you do, or if you had it, then it would fall on you to make sure that you maintain a copy, just to safeguard yourself. Now, should the district maintain a copy? Yes, but that would involve them printing out the Class Dojo, and that would take a lot of time. And I can see that at the end of the school year, if there were no issues, I can see them doing that. Now, is it right? No, I wouldn't say it would be right. But see, if your child doesn't have an IEP, then your child wouldn't, you know, the statute of limitations with regards to your, let's say, 1 year or 2 year statute to go back and complain wouldn't necessarily be there. Now, under child find, if they end up identifying your child as having a qualifying disability and being in need of specialized instruction, then yes, you would have a due process case to be able to go back, and you could go back as you know, as far as 2 years or 1 year, whatever your statute is in your state, and say that the district knew or should have known at that point that my child needed an IEP and then failed in their child finder responsibilities. And at that point, yes, your child would be entitled to compensatory or remedial services from that point to when they were eligible. Okay, so yes, that Class Dojo stuff would be important. So they should be maintaining a copy of this stuff. I mean, you know, it's just, I'm not telling you anything that you don't already know or suspected. But, you know, and it's just not normal. No, it's not normal for this stuff to just go away. But, you know, like I said, I've seen it too much. I mean, they're gaming you. So what I'd like to know is, have they not even moved forward on a request to evaluate? Is that the problem? I mean, they're saying that there is no issue, and because you don't have anything to point to. And this is the other thing, guys, if you have parent-teacher conferences, either maintain your own notes or demand a copy of their notes before you walk out of that room. Don't let them have a monopoly on this stuff. All right? These aren't state secrets. So, you know, get a copy of them next time. And you may have to start fresh and build a new record, you know, because if they're saying this, it doesn't exist. I mean, you know, I don't know if I believe them, but how are you gonna afford? You know, that's the thing, is it's a one-sided advantage when it comes to the maintenance of school records. The schools have that duty, and I've been in far too many cases to where they lose it. They trip and fall into the paper shredder. The dog ate it. You know, I've had a special education director keep stuff in a personal email folder. And, you know, we ended up busting her, and she ended up having to print it all out of her personal email folder. And it was very critical information and we were in a due process, and we were at the tail end of our due process hearings. And we ended up discovering that she was holding very critical documents in her own personal email folder, and their own attorney didn't even know about it. And he was livid when he found out, because he had been lied to as well. So, you know, this is unfortunately the game we're up against sometimes as parents.